Hello, my name is Jason Killinger. I'm a professor at the Pennsylvania College of Technology, and today I am going to give you a presentation on current copyright laws. Uh, Hopefully, by the end of this, I will provide you with a better understanding of current copyright laws and how you can prevent yourself from infringing on these copyright laws, and hopefully clear up some of the gray areas you might have about current copyright laws and policies here at the Pennsylvania College of Technology. So our first thing that we want to do, we want to put a definition to this. Copyright is a form of protection provided by the laws of the United States for original works of authorship, including musical, pictorial, graphic, art, audio, and video creations. Now, what does this mean? Basically, copyright, it means the right to copy. But we also have to look at this gives the authorship an exclusive right to their work, so it protects their work. Now, under Title 17, we have to look at what the owner's rights are to their copyrighted material. So, under Unit Title 17 of the U.S. Code, Section 106, the copyright owner has the right to control, and his right to control is within the reproduction, distribution, creation of expanded new versions, public performance and display of their work, moral rights to some works of art, specific rights regarding performance, reproduction, and transmission of sound recordings. As educators, we have to look at the basic 9 statutory exceptions to the rights of copyright owners, because this is what allows us to open up those doors a little bit and cut through that red tape as educators or students or librarians to be able to utilize some of this work to educate. So we have to look at fair use. That's the huge one there of the 9, and it's probably the most important one. And a lot of us, we run around and we say, "Oh yeah, I'm covered under fair use," but we have to make sure that we meet the guidelines to cover our material under the fair use policies. Some of the things in my mind that I try to keep in my head about fair use, there's 4 things. The purpose of the material, the nature, the amount we're going to use, and the effect. When I say effect, is there any type of gain, financial gain? And as long as we're using it for education and it's nonprofit, normally we're going to be okay under those guidelines. The next one is library copying. This is an interesting one because we've all walked into libraries and we've pulled up material and we've copied it. So, what this does under current law, copyright law, this protects our public libraries. So, if a person goes in there and makes a copy of something, the library is actually protected because they have ownership of that material. Plus, it will also need to show when we make that copy that this might be a copyrighted reproduction, or also a lot of the archives, when we do print them out in the library, I know especially here at Penn's College, you'll see that the copyright is stamped at the bottom of those archives, telling you that it is a copyrighted material. So the libraries are protected under Section 108. First sale. That's another interesting one that we have to look at, Section 109, when we are looking at first sale. I guess I'll start off here with an example of first sale. So I go out and I buy a CD or a book. I have the right to resell the book or the CD, but I don't have a right to make copies of it. So it's first sale. So a lot of libraries are under this exception as well at Section 109 because of when they buy a book, we lend material. So we can't reproduce it. We can lend it or sell it, but we can't reproduce it as long as we own that copy. Public display. This one here falls under the guideline that if I do buy a copyrighted piece of material, so let's say I buy a piece of artwork, if I want to display that artwork, it's my right to display it as I would like to display it. I don't necessarily have to follow any guidelines that are under that guy that holds the copyright on that material. So if I want to put it in a store window a certain way with other objects, I can. So I have the right to display it in a public manner the way I would like to. Display and performance in face-to-face teaching. Most of us do this every day. We have material that we use. We put up on PowerPoints, overhead projectors, and our face-to-face meeting times with our students. And that material is also under this statutory exception. Uh, you know, I always provide references or resources to where I got that material on all my PowerPoints anyhow, so I kind of protect myself, and I recommend you do the same thing. Display and performance in distance learning. When we look at distance learning, we have to say, okay, how do I need to present this material, or what's going to happen here, because obviously we are transferring a lot of material to an online format. So it's not as typical as the face-to-face setting. Well, the TEACH Act, which was revised in 2002, addressed many of these issues for online education. And it allows us now to post a lot of material onto servers that we can get onto our online classrooms. Still, there is a lot of conditions that have to be met with that. So a lot of us as online educators are still going through fair use, or just asking permission to use that material, versus going through and trying to utilize the TEACH Act, because the stipulations, I mean, yes, we can follow them, but some of us have found that it's just easier to go under the guidelines of fair use, or just simply call up the copyright holder and ask permission. Computer software, that's in section 117. If we look at computer software, this allows us to own a copy of computer software. We can modify it to use it on our computer, and we can also make a backup copy of that software in an event that we have a damaged system, or something happened to our original copy. So this helps us out as far as educators, and also as individuals at home, that when we buy this, we can back up our computer software. Architectural works, architectural designs, if this is also protected under copyright. So if there's blueprints or something that's out there that were used to construct a building, yes, they're copyrighted. But if I take a picture of that building, uh, I'm not currently infringing upon copyright. So it's in a public display, a public manner, once it's constructed or built at that time. So I'm allowed to utilize that. It's not a copyrighted item, so it doesn't have to go back to the architect and ask permission. Can I take a picture of your building and put it in a postcard? That's not necessarily the case. Special floor mats for individuals with disabilities. What we're looking at there, if we have a special format for a person with a disability, so let's use an example, we have a blind student in our class. We can go ahead and we can publish that over to a different format, and allow that student to have it. We don't necessarily have to go back and ask the copyright holder if we can do that. So we're able to go ahead and transfer that format over for that student with a disability. So that pretty much sums up the 9 statutory exceptions that we can take advantage of as educators through current copyright law and policy. So we went through, and at the beginning I told you what the protection, the rights were of the holder or the owner of the material of the copyright. We went through and I talked about some of the exceptions, the statutory exceptions, and now we're going to talk a little bit about what copyright does not protect. So copyright, ideas, procedures, methods, operations, systems, processes, concepts, principles, discoveries, or devices. These are not covered under current copyright law. If you look at what they might be covered under, you might be looking at a U.S. patent. So some of these things might be covered under a U.S. patent, not so much a copyright. So you might have to go back to the patent holder and figure out how you want to present that if you're trying to use one of their systems, ideas, procedures, or methods. Work, not in tangible form or expression. So, things that haven't been in a hard format or have not been out there, they're not covered under copyright protection. Titles, names, short phrases, slogans, familiar symbols, or designs, they would be not protected under copyright. Now, most of us can make the argument, well, they got to be protected. We've seen this. Well, it's not a copyright protection, so it doesn't go under copyright law. These would be done through trademark, so they would have a U.S. trademark attached to them. That's their protection. Works consisting entirely of information that is common property and containing no original authorship. An example, a calendar, a daily planner. Things that have no original authorship, they would be things that would not hold any type of copyright or be protected under copyright. Tape measure would be another one. U.S. government work. These are not protected under copyright. So anything that was published by the U.S. government we can use as educators. And then, of course, there's always an exception, state and local government or commission work that would not be excluded, that would be protected under current copyright. Works for which copyright has expired, this would push us back to the date of, let me think here, trying to think, 1923. So anything published prior to 1923, their copyright might have expired and it might not be covered under current copyright law or protection. So there are things that we have to look at. These are things that wouldn't be protected, and not saying there's not some other type of protection on them, but they're not covered under current copyright law. So, as educators, most of us are working towards being online educators or are already doing online education, and we all do this, whether it's a face-to-face setting or an online classroom. We all look at material. So one of the easiest ways to transfer material anymore is we go out to the World Wide Web and we Google. So we go to a search engine and we Google. It might be Google, Yahoo, whatever. I'm not trying to promote Google, but whatever. We go out to a search engine. Everything on the internet is not public domain. We have to go out and ask permission. It might be copyrighted. And there's ways that we can go in and check to see if the material is copyrighted or not. Google, they have a pretty neat feature that we can go in and tell it that we don't want anything in our search that would be copyrighted protected, and it'll bring that up. So we have to make sure that we use caution, make sure that we understand that not everything on the internet is public domain. It might be copyrighted. We have to ask permission in order to use that material. So there's a lot of neat tools out there, like I said, but the wisest course of action is to ask permission. So whenever in doubt, ask permission. Go back to the web master, whoever's on that site, and ask permission if you can use this material. Or another method that we can use is Creative Commons, which gives us another viable resource that we can go out and see what material is available to us that has been published or created under the Creative Commons logo, and what access we have as educators to utilizing that in our lessons plan. So that's it. That was my take on copyright laws. So I'm hoping that you found this presentation informational and it cleared up any of those gray areas that you might have on what is copyright, who the owner, what their rights are, what the statutory exceptions that we have available to us as educators, and what we need to do before we use material in our online setting.